On the 11th of March of 2022, the Divisional Court handed down judgment in Leigh and Metropolitan Police Commissioner, which is reported at 2022, 1 Weeklies 3141. The case concerned the interplay between the restrictions on outdoor gatherings at the height of the COVID-19 pandemic and the rights to freedom of expression and freedom of peaceful assembly. The background was that at around 9 p.m. on Wednesday the 3rd of March of 2021, Sarah Everard went missing whilst walking home from Clapham to Brixton Hill in South London. 6 days later, on the 9th of March of 2021, the Metropolitan Police announced that a serving Met Officer had been arrested on suspicion of her kidnap. The man in question was Wayne Couzens. The following day, Sarah's remains were found, and 2 days after that, Couzens was charged. He later pleaded guilty to kidnap, rape and murder, and he received a whole life sentence. The judgment the subject of this video case review relates to the attempts made in the week following Sarah Everard's disappearance to organise a vigil in her memory, a vigil which was also intended to highlight risks to women's safety and to campaign for changes in attitudes and responses to violence perpetrated against women. A collective called #ReclaimTheStreets wanted to hold the vigil on Clapham Common on Saturday the 13th of March. The event had been advertised and large numbers had shown an interest in attending. However, this was all happening against the background of the regulations which were then in force for the protection of public health during the pandemic. Those regulations placed restrictions on public outdoor gatherings of more than 30 persons in any so-called Tier 4 area, which included London. And they made it a criminal offence to contravene the regulations without a reasonable excuse. And they gave the police power to arrest anyone that they reasonably suspected of committing such an offence, or alternatively a power to serve such a person with a fixed penalty notice, imposing a fine of up to £10,000. In the end, Reclaim the Streets abandoned their plans for a vigil. And it's worth emphasising that the gathering which did ultimately take place that day on Clapham Common, in the course of which the police controversially made a number of arrests, was not the event which Reclaim the Streets had been organising. They blamed the cancellation of their event on a succession of decisions by the police, all of which they argued were based on an erroneous interpretation of the regulations. Specifically, they contended the police had been wrong to categorise the proposed vigil as criminal merely because it involved more than 30 people gathering together in a public outdoor space within a Tier 4 area. The police had been, so it was contended, under a duty to carry out a proportionality assessment, but they'd failed to do so, and they'd ignored the possibility that a reasonable excuse for contravening the regulations might have been provided by the rights to freedom of expression and freedom of assembly under Articles 10 and 11 of the European Convention on Human Rights. In handing down judgment on a judicial review application brought against the then Metropolitan Police Commissioner, Dame Cressida Dick, Lord Justice Warby referred to paragraph 5 of Schedule 3A to the Health Protection Coronavirus Restrictions All Tiers England regulations of 2020, and to a number of authorities, including Dolan and Health Secretary and DPP and Ziegler, both of which had been the subject of earlier Crimecast videos released on respectively the 17th of February and the 23rd of December of 2021. His Lordship then held as follows. Firstly, a person attending or organising such a gathering would have a reasonable excuse for contravening the restriction and would not commit an offence under the regulations if their conduct amounted to a lawful exercise of the rights protected by Articles 10 and 11 of the ECHR. Secondly, whether their conduct did constitute a lawful exercise of their convention rights would depend on a proportionality assessment. Thirdly, since the burden of proving that a defendant had no reasonable excuse lay on the prosecution, a consideration of whether that burden could be discharged was fundamental to the lawfulness of any decision to prosecute for an offence or to issue a fixed penalty notice under the regulations. Similarly, an exercise of the police's lesser powers of enforcement under the regulations also had to be justified by reference to the requirements of necessity and proportionality. Fourthly, therefore, the police could not make any form of enforcement decision under the regulations without first carrying out a proportionality assessment, as part of which the police would have to make some assessment of the seriousness of the health risk and balance that against the convention rights engaged. They couldn't simply assume that any gathering caught by the regulations would pose a serious risk to public health, nor could they ignore the available evidence regarding current public health risks. Fifth, the various police decisions, the subject of the JR application, had all contributed to the eventual decision to cancel the vigil, and they involved an interference with the claimant's convention rights. None of those decisions have paid proper regard to the reasonable excuse provision, since the police had failed to conduct a fact-specific proportionality assessment, taking all relevant factors into account, including the public health risks and any steps that might have been taken to mitigate those risks. And so, for all those reasons, the JR claim was allowed, and the court granted a declaration that the various police decisions under review were unlawful. But the court declined to award damages, holding that the declaratory relief vindicated the claimant's rights.